Welcome to our broadcast. I'm your host, Michael Lange, and this is Oakland Is. Today we're going to do a follow-up on the Oscar Grant trial, which recently resulted in a decision. And with me again is Minister Keith Muhammad, who is here from Oakland, and he has been present at most of the hearing in Los Angeles, and he's back here to give us a full report. I want to thank you for coming on the program.
Thank you for having me.
Yes, when we last left, a few people called our show and said, where is the peace in Oakland? Where is the effort to create peace in Oakland now that this decision has been made? So I wanted to get a recap if this decision that was made on Mehserle was a just decision. And then number two, what can the audience do in terms of their civic responsibility to do follow through to make sure that that the businesses don't get smashed, or I understand that there's been some I don't know what we call it, agent provocateur type stuff, people waiting for an incident to happen so they can do their little thing, and just kind of give us an update since the last couple of weeks.
Well, first I should say that while we were in Los Angeles and received calls that the verdict was in dialogue with our attorneys, Mr. Burris and others that have interest in the case, it would be said that a fast verdict is unlikely. There were so many elements and decisions to be made by the jury. The jury had 3 different levels of crime to agree or disagree on. So we fully anticipated that the verdict would take days, even potentially weeks, to arrive at unanimous decision. The jury first had the task to consider second-degree murder, and it had to come to a unanimous decision that either it was second-degree murder or that second-degree murder is off the table. Then the jury had the task of arguing or deliberating over voluntary manslaughter, which was the next most serious crime for which Mr. Mehserle was charged. It had to have unanimous agreement that it was or that it was not voluntary manslaughter. The least serious charge was involuntary manslaughter. In other words, to come to a decision, the jury had to go through arguments which began with the most serious and
worked their way down.
And works its way down to what would ultimately be the least serious, and then agree or disagree on what those charges are. What was disappointing and, quite frankly, surprising was that a jury, without taking a full day of deliberation, could resolve all of those issues so quickly. In the case of O.J. Simpson, when a jury comes back quickly, generally it meant that the state did not meet its burden of proof and the jury was clear, this is a not guilty verdict. Very rare you get a guilty verdict that requires deliberation over various points, and it comes in that quickly. We were shocked. And if you watched Uncle Bobby, or Cephas Johnson, Oscar's uncle, I think that was the only day that you saw him come before those cameras and he wasn't wearing a suit. That's how quickly this happened. That jury did not take a full day to deliberate, and to come in with the decision with so many nuances to the charges that quickly, we knew that something was wrong to come in that quickly, and we were not satisfied. Oscar's mother, Wanda Johnson, myself, the rest of the family, and the community at large is not satisfied that involuntary manslaughter is the greatest charge for which guilt could be established. So now, that being said, where do we go from here? Well, first, there's a sentencing. That date has now been reset to November the 5th. And the reason that we are surely not satisfied is that with involuntary manslaughter, the potential sentence can range from probation. He can be given time served and the balance of time on probation, which means that Johannes Mehserle can go back home November the 5th if the judge sees fit. There are 2 charges he's responding to. One is the involuntary manslaughter charge, which carries a few years of potential jail time. But the greater charge actually is the weapons charge. So with the weapons charge, he could be sentenced up to 14 years based on the judge's final decision. So given that the defense for Johannes Mehserle is bringing a new argument, he has asked for more time. The original date for sentencing was August the 6th, which would have been this week. It's been delayed because the defense attorney wants to argue that since Johannes Mehserle was a police officer in performance of his duty at the time of the shooting, that he should not have to carry the weapons enhancement charge that others carry when they commit crimes and are charged with both the crime and the use of a weapon.
You can see the hands are moving to set him free, or to at least reduce the amount of time that he served. How important is it to get this extra 2 months to negotiate or navigate on behalf of Mehserle to get him even a lighter sentence then?
Well, I've learned from defense attorneys in the past that they'll ask for extra time because of the balance of it means that we can cut years off of a sentence rather than and permit our client to spend an extra few months behind bars. They're more comfortable with those few months behind bars than they are having to wrestle down 10 or 14 years of sentencing. So it's a tactic that's been made by the defense attorney. I was in the courtroom when the verdict was rendered. And right after the moment that the verdict was rendered, the judge asked the attorneys about a list of dates for sentencing. And in that moment, before he had given it further consideration, the defense attorney for Johannes Mehserle agreed to August the 6th.
Okay.
He came back later after perhaps seeing an opportunity to offer a legal challenge and requested more time. And I know the judge has to give consideration to such requests.
Sure.
But if we watch how the wheels of justice roll when it has to prosecute one of its own, it seems to offer every consideration possible to give comfort to the defense in this case. If we go all the way back to March the 18th, I think it was, or the month of March of 2009, when the preliminary trial was to have begun, they pushed it back in time because some OPD officers had unfortunately been in conflict and lost their lives in the performance of their duty. And they pushed back the trial for the murder of Oscar Grant another couple of months. So it seems as though in defense of this defendant, the system of justice has been very kind to him. But if Oscar Grant were the defendant, would you find these kind of delays?
Yeah. And of course the answer would be no. You wouldn't find it. But I'm going to ask a question about the number of police officers present on the day, January 1st of 2009, in terms of the tactic that police use to outnumber a suspect. Can you speak to that?
Well, it's been common in a military order that you don't tend to move out in an attacking way until you've got superior numbers. And in the night that Oscar was murdered, BART PD surely had superior numbers over Oscar Grant and his friends who had been detained. The actions of Johannes Mehserle in the alleged attempt to handcuff Oscar Grant were unnecessary. The kind of force that he used, the fact that he even considered laying Oscar Grant on his face was unnecessary. And as we watched the trial, and I learned more about policing standards in that trial than I've ever known, I learned there that there's a standard upon which an officer places a suspect on his knees, and there's a standard on which an officer lays a suspect on his face. Well, Oscar hadn't met any of those standards.
So he shouldn't have
if he
been
needed
there.
to be under arrest for any action on that evening, he never needed to be on the ground. It was Officer Tony Peroni who slammed him to the ground with a forearm shiver that took him down to his knees. Then it was Officer Johannes Mehserle who threw him to his face after he landed across the legs of his friend Carlos Reyes. And what they called resisting arrest was Oscar's inability to get his hands behind his back when they threw him on his face with his hands in front of him across the legs of his friend with 500+ pounds of police officers laying across his head and torso. So what they called resisting arrest was never resisting arrest. And I can remember distinctly that Officer Tony Peroni, the one who hurled the racial epithets at Oscar, said that if Oscar Grant had not been killed, that they would not have even taken down his name. So that meant after the hammering, after the forearm shiver, after the throwing him down to his face, that if there were not firearms that killed him, that this would have been another case of a young black man who went home with a hickey on his head, some stitches on his lip, that would have complained to some source that he was brutalized by police, and his case would have been ignored. Videotape made this case. It was not the reports of the officers. The reports of the officers were inaccurate and were in fact lies. Not a single police officer at BART testified that they heard a gunshot. And that includes the officer who fired the shot, Johannes Mehserle. Every one of them testified they heard a loud sound, a strange noise, a taser malfunction. Well, what that meant was, from the beginning of the reporting process, that the cover-up was being laid. If you watch in the city of Oakland, which just lost a $6.5 million lawsuit for the Riders case, Attorney Burris, who's also the family's attorney for Oscar Grant, has seen through a case to its conclusion that was settled, and that case was false reporting. You cannot get justice without truth. The officer of the law is duty-bound to report the truth. That's why when police officers come into court, their testimony seems to carry greater weight than just about anybody else's. Well, with great weight comes great responsibility. And every officer that told less than the truth shirked his responsibility to the public, which is a shame because the public is paying every one of their salaries. Every penny that they earn comes out of the pocket of the public. So to go in and testify to protect the institution of policing rather than protect the presence of justice is really a crime that has to be addressed.
How do you think training addresses this issue of whether it's racial profiling, whether it's this is a young person, I'm going to slam him down, I've got the training, and it's like the film Training Day, well, all that, just forget about what you learned in school. This is the real world here. Can you speak to the training aspect that may result as a result of this particular incident?
Well, as we know, as a result of this incident, BART had to replace its chief of police. And the new chief disarmed its officers for a time of the use of tasers. Unfortunately, even though this has occurred, we have to now address the mindset of policing work itself. The police officer should never see the people that in LAPD they use the model to protect and serve. You cannot both protect and serve and see those that are alleged to have committed some violation of the law as your enemy. There's a difference between domestic policing and international international warfare. If officers of the law approach those that they're duty-bound to protect as enemies, then they will treat them as enemies or enemy combatants.
Even though they're your taxpayers.
Even though these that you are arresting are paying your salary. And that's the difference between military and law enforcement. Unfortunately, too many law enforcement officers enter communities as though they have the mindset of an occupying army, so that these young, particularly urban youth, appear to be dangerous to me. Their pants are sagging, their hair is twisted, their skin is dark. Therefore, I'm not judging them by the content of their character. I'm judging them by the quality of their appearance, and rather than to serve that young man. How many young men or women have had the urban look, been in need of help, and have found themselves ignored? And just as you would find those who try to flag down a cab and have the urban look, and the cabbie won't stop and serve them because of the quality of their appearance. So we would hope that law enforcement officers would take training in racial sensitivity beyond the 1 hour speech they get while in training, so they can invite Reverend Brown or Reverend Smith or Minister Muhammad to come give a 1 hour speech as they go through weeks of training, and they give us a big round of applause for that 1 hour speech and say, now get out of here so we can go back to business as usual. This is a training that has to be constant and continuous, because the best police officer or the best fireman is the one that serves. I watched on the news as they were contemplating laying off fire officers or fire department members in the city of San Jose. And they had children hugging on their legs and thanking them. And I had a wonderful officer in OPD tell me one day, a good brother, he said, you know, it hurts, because when we drive through the community, he said, the people give us the finger. But when the fireman goes through the community, the people and the children wave at them and jump on the fire truck. That is because they see, and we see, firemen as community servants. But in the black community, we don't enjoy that relationship. We see law enforcement, and many times as an occupying force.
As a metaphor, it's a fire of a different type. And they're putting the fire out, the police officers, with force.
Yes.
You know, so that's, you know, I wanted to ask another question. We get back to the trial, because there were people who were part of the original jury that were removed and somebody replaced them. Can you clarify what happened there?
Well, this goes to the beginning of the jury selection process. When this trial began, the judge declared that he thought we'd be out of there by the 4th of July.
Wow.
So he was intent on streamlining the process. He questioned the attorneys in the initial phases. What is it that we're proving here? Is there any dispute over whether or not Johannes Mehserle pulled the trigger? No, Your Honor, there's no dispute. Okay. Then the only thing we have to do is prove intent. Yes, Your Honor. Okay. Then I think we'll be done by the 4th of July. When we have jury selection, let's produce our questionnaire, and we will bring in 200. And if we can get a jury out of the initial 200, then we're ready to move forward. They found the jury in the initial 50. And in that initial 50, every potential black juror was excused on the onset. So the judge, as I understand it, excused 2. The defense attorney used his right as a defense attorney to excuse 3. And unfortunately, we don't see whether the DA brought challenge or opposition to accusing the black members of the jury. I had a chance just on yesterday to watch a documentary on the murder of Medgar Evers and how Dela Beckwith, the murderer of Medgar Evers, went to trial twice in Mississippi with all-white juries and never could be convicted. And the time that he was finally convicted, 30 years later, was the time that the jury pool changed. Black folks gained the right to vote and were able to exercise that right, and therefore participated in jury pools. And so when Dela Beckwith was convicted for the murder of Medgar Evers, it was when it finally came across in time that he would have to confront a jury of Medgar Evers peers that reflected the area of Mississippi. Los Angeles is 25% white. That jury was 75% white. Well, how is that? And we should question that, and we should challenge it and sound it on every mountaintop that we're not satisfied that the jury selection was what it should be. We appreciate that they found a guilty verdict. What that cleared to us was it was clear that this man was guilty of something. But in my vantage point, that jury compromised. How do we get this out of our face very quickly? We can't say not guilty because he clearly shot Oscar Grant. But the question becomes, how are we going to punish him? And it appears as though that jury struck a compromise.
So how one way, of course, is to, in terms of civic responsibility of the people watching the program, the person should think about serving. If you get a call, I just got a jury summons, so I should be there. I mean, if for any reason, I mean, I get eliminated, that's me being eliminated, but I should show up for me, for the citizens of Oakland, for a jury. What are some other strategies that the audience can use or look out for so that they can create justice, peace and justice in the city of Oakland?
Well, first in this case, the organizers that have been working to bring justice in the murder of Oscar Grant along with his family are asking that the community write Judge Robert Perry, care of Attorney John Burris, so that we can express our desire that this man be sentenced at the fullest extent of the law. Secondly, the Department of Justice, which recently demonstrated its capacity in New Orleans, where police officers killed some innocent men and women during Hurricane Katrina. Those officers weren't convicted in a state court, but the Department of Justice has now intervened to fully investigate. We would say to the public, support Mayor Dellum's and Congressperson Lee's request that the Department of Justice engage this case. As I understand it, the Department of Justice won't fully engage until sentencing occurs. So as we are awaiting that time, we want to continue to pursue the Department of Justice to do all that it can. We think that, quite frankly, every person of concern should say to the Department of Justice, first, we're not satisfied with involuntary manslaughter. So that even if there is sentencing at the fullest extent of the law at involuntary, I think that there's still civil rights violations. And if we have to set a precedent here, why don't we just start right here? Precedent has been set. Johannes Mehserle is the first officer in the state ever to be charged with murder. He's also the first officer in the state to be convicted for this kind of an action while on duty. So since we're doing some things for the first time, I heard Johnny Cochran's firm declare that they had never seen a single police officer in all the cases they've dealt with fired. They've never seen an officer punished for what he's done for an on-duty act. Well, Mr. Burris said the same thing when he got up after the verdict had been announced. So historically, we have seen some great strides, but we're not satisfied. If you stick a knife in my back 12 inches and pull it out 6 inches, I'm not going to jump for joy and cheer that this knife is still in my back. Thank you. You pull that knife out, it still hurts.
That's right.
So if you were Wanda Johnson, Oscar's dear mother, if you were Cephas Johnson, Oscar's uncle, if you were Tatiana, Oscar's daughter, if you were Sophina, Oscar's girlfriend, pulling that knife out a few inches, it still hurts, still needs healing, and we still need to get that knife out of our back all the way. So we're asking the community to continue to organize, stay vigilant. There are still other actions that are involving the death of people at the hands of law enforcement. And Oscar's family has become really a voice in the face of a movement. So we can't stop when this case ends, because before we got home, OPD and BART PD in a joint maneuver killed Fred Collins, 8:30 in the morning, just 2 Saturdays ago, in a case that is still being investigated. So we want to be clear that police brutality did not begin with Oscar, and unfortunately, it has not ended with Oscar. In Union City, a young woman, pregnant, 7 months, Tanisha Black, was pulled over by CHP for talking while driving on her cell phone. Well, of course, there's a law-abiding earbud, and when they approached her and asked her to get out of the vehicle, they tased her after she told them that she was 7 months pregnant. And because they didn't like her attitude or something of that effect, now here she is, not knowing what the long-term impact will be on her unborn child. If she knew what I have learned about the nature of the what's in our womb, and what fear does to an unborn child, what pain does to an unborn child, that child will be marked for the rest of its life for what happened to her that the child didn't even see. And so for an officer of the law to deploy a taser on a 7-month pregnant person, see, again, these that we serve from law enforcement, as you know, the Nation of Islam Brotherhood and Sisterhood, we do security. You've seen us walk with many stars and many people in many places. We did security for the Million Man March and did not have a single fight, not a single incident while we were there. And the reason for that is we love who we secure. So when we're hired to do security, We are in love with the people that we're securing,
Yeah.
and in some occasions, depending on the event, we may be in love with the people who are the crowd at the event. So if we go to perform security at an event, Black Family Day,
Yeah.
well, we're in love with the stars that are performing, and we're in love with the people that
who-
have come in the crowd. And if a young man or a young woman gets out of hand, we say, hey, brother, sister, come on now.
Yeah, yeah.
You know better.
Yeah,
This is
yeah.
a family event. Put that thing away, and you'll find that people are responsive
Sure.
to love.
Sure, they are. They do respond. You know, I was just thinking about the acknowledgement of the knife that's in the back, as Malcolm X would say. They don't even acknowledge that the knife is in there. So whether you go in 12 and come out 6,
Which for 19 months, Johannes Mehserle never acknowledged.
Yeah.
Which is why his attempted apology, which didn't come in the trial, came after
Yes.
he was found guilty.
It seemed
and
like to
at
be
the behest
timed.
of his attorney, that he would send a letter to the public apologizing for what he's done. If it were his concern that he's taken a life and the family has been made to suffer, January the 1st or 2nd, 2009, he could have easily made an apology. He didn't. So for 19 months, his attorney attacked Oscar Grant's character. For 19 months, his attorney attacked the activist that stood up for Oscar Grant. For 19 months, his attorney attacked the friends of Oscar Grant, accused them of resisting arrest, of bringing on this instance or this situation onto themselves. For 19 months, they argued that the problem here were these young men.
Yeah.
Well, now that his client's been found guilty, and he advises his client to write a public apology. I mean, that's nice, but is it sincere? If it were sincere, it would have been directly to the family. He could have done it from the witness stand and could have looked out at Oscar's mother and said, Mrs. Grant,
Heart to
it
heart.
has been for 19 months terrifying for me to have not spoken to you. I want to publicly apologize. Make the judge stop it. But if you are really sincere about giving that kind of apology, and you take the time, you make the time, forget the law, this is humanity.
Okay.
And as I'm a human being and your family are human beings, then let me do the human and the righteous thing. And my lawyer will have to hash that out at some later time.
Yeah. Well, I want to thank you for your insights into this whole ordeal. It seems that there's a little bit left to happen in November when there'll be a decision made about the sentencing. So we'll be right on that, and hopefully we can get back together with you and get your response to the sentencing that will take place, or I guess the length of time that will finally be decided. Thank you for coming on the program.
Thank you.
Yeah, okay.